Hey everyone, thanks for joining. This is Who Do You Think You're Talking To? A discussion on perspectives of legal writing. And here we have David Cole and Dina Stroh, two legal writing experts who I admire very deeply and dearly. I've had the pleasure in talking to them and trying to asking them, some advice about legal writing. I'm a, fifth year attorney at Crawford Wishing Lang. And I'll let David and Dina introduce themselves if they have anything to say before I get into the topics.
Hello, David Cole. I'm with Lynn Pinker, Hurst and Schwegman. My practice is civil appellate law, so I write for a living. I've known Dina and David both, Dina for a little bit longer than David. Like them both, and very happy to be here on this panel with them.
So Dina Strom, General Counsel at North Texas Tollway Authority. I do probably less writing myself and more editing and reviewing other people's writing, which is probably going to be helpful in this panel. I will say that having known David Cole a little bit longer than I've known David A., that he's the one I turn to when I have gobbledygook that needs to be turned into something that makes sense. And so I'm thrilled to be on this panel, especially with David Cole, who I consider a mentor as well as an excellent writer.
Well, awesome. I definitely appreciate y'all both taking the time to be on here today. And I can't wait for us to learn a little bit more about our writing skills and how we can improve them in the litigation world as well as the transactional space. Any tidbits that you may have to know, because, I've had some gabagool and it definitely needs some help. But getting started, I just wanted to ask, first, one of the legal principles that we talked about, unifying principles in legal writing that goes across all practice areas. So one of the first things I wanted to ask you about was, who is the target audience and what is, the most important thing about conveying writing to the target audience?
I'll start and we can kind of trade off who goes first. But anytime you write anything, unless you're writing in a diary, you're writing to somebody else. And so job one is, who is the person I am writing to, and what is it I wish to do with that person? Am I informing them of something? Am I persuading them of something? Am I just being friendly? What is the goal of this communication that I'm having with this specific person? And so that's the first thing, is think, where is this going? Part of that, I think, is we tend to overlook sometimes, particularly when writing becomes more formal and it's a longer exercise for whatever reason, is defining who your audience is not. So if I'm writing to so-and-so, who your audience is not your high school English teacher, and it is not your first year in law school writing instructor. Those people were wonderful people. They played an important role in your life, teaching you basics and teaching you certain principles of style, but they're gone. You're past that. You graduated from high school, you graduated from law school, and you need to build on what they taught you. You're not talking to them anymore. You're not getting a style grade. Your point is to effectively communicate something, information, request, whatever, to a specific person. And keeping that in mind at the outset and all the way through whatever you're doing is more important to keeping you on track than probably anything else we're going to talk about today.
But let's go into a little bit more specifics. I think you've got the client. So I'm a good example of that. And let me put a pin in that and go to it later. You've got a court. And that's going to have to be more persuasive, of course, in terms of the type of writing. You've got business people. Sometimes with transactions, you don't interact necessarily with a lawyer. You're interacting with non-lawyers, and that's a whole separate type of legal writing that I know a little bit about that as well. But say you have in-house, someone like me, I'm a lawyer, but you don't know necessarily what I'm going to do with it. So it's not just who, it's also the context of the why. If you can figure out the why of why am I asking a David Cole to rewrite something to go to somewhere else, then he has an idea of it's like an indirect who is receiving it. So not just the initial who, but downstream, who is going to receive the work and what does it need to look like?
Yeah, I think that's very key. I know we talked a little bit about strategy in terms of writing, but knowing your audience and having the right strategy, and going from a partner to a client to a business owner who's maybe looking over it, or the courts are a little bit different. But is there a specific type of like writing that you like to see in particular, whether it's an email, do you like, or if it's a longer writing to a client or something to the court, just generally, whether it's being concise, being short, short sentences, key facts, and what is the most important, what are some of the most important aspects of writing that you can really just emphasize for us to know?
I'll
So
say generally speaking. Oh, go ahead, Dan. I'm sorry. You go
I
ahead, please.
figure you can build on to anything I say,
Mhm.
David, because really what my focus is in terms of like, who do I write for and who
Mhm.
does work for me? So I write for business people. Business people, I mean, David A., you kind of alluded to it. They need something short and sweet, and they need it to be in normal human language. It does me no good to talk about force majeure to a non-lawyer. What it does help me communicate to them if something has gone wrong and who bears the burden, right? So it's for my business people, even those who are sophisticated and deal in legal documents. I try to make sure it's in normal human language and it's short. These are very busy people. They do best with bullet points of this is what it is, this is why it is, this is the decision that needs to be made. For me, if someone's writing for me, I could have it for any number of reasons. I could have something, and I try to signpost, let my outside counsel know what is it that I need it for. But signpost of, is this going to go to a business person? If it's going to go to a business person, that makes it clear that I have to have normal human language, right? Is it going to go to me? Am I keeping it to put a legal memoranda in the file in case something goes sideways in the future? That might be a little bit longer. If it's just me, if I just need the answer, it's going to be an email. I just need an email with the answer. And that is effectively my communication to you as a lawyer doing my work of how is it going to be used and the why. A lot of this goes back to why. Why are you doing the legal writing?
Yeah, the one thing that cuts through all of those different, or pervades all those different approaches, the audience and the why, is the communication has to be user friendly, and user friendliness can be different for different people. Right? If Dina's writing to the CEO or whatever it is they have at the tollway, I mean, he doesn't have very much time. There's a certain way, and Dina's gotten to know that person, and there's a certain way they like to communicate, and they need to hear it that way because that's how they process information, that's how they fit it in their schedule, that sort of thing. Another CEO comes along, they may have a different style. So you want to be user friendly. A lawyer will understand more vocabulary, might be more interested in more nuance, they get more stuff. There is a fine line between being user friendly, being succinct, being organized, using appropriate signposting, whatever good principles of writing you may use there, between being user friendly and being silly. In terms of having too much of that, too much signposting just to be signposting, too many. And a good example of that is a lot of the AI slop that comes out of ChatGPT. If you don't regulate it very carefully, it loves highlighting, it loves bullet points. It looks good, it's just gobbledygook on the page. And so simply using bullet points and gimmicky stuff to make your writing look user friendly doesn't mean that it really is user friendly. So don't, in your zeal to try to get to the point and be a good communicator and be effective, don't get so hung up on the details of that you inadvertently shoot yourself in the foot by becoming sort of a caricature of good writing. User friendliness means being friendly, not just checking off a bunch of how to do it stuff.
Yeah, I think that's a great point. And I know, David, when I've worked with you in the past, you've really emphasized certain specifics in terms of, whenever I'm writing, one thing that I improved on earlier on in my career was being able to, shorten my sentences because I had the tendency to be long-winded and thinking, hey, I'm not being as user-friendly because I wanted to get everything out. But sometimes you have to get straight to the point, and using key facts and key authority, and also just being able to use active voice in order to avoid redundancy. But particularly, as you mentioned, trying to use displays and headings and topics to be able to tell the reader where you're going to and what they're looking for.
Mhm.
Is there a certain type of typography or, a visual aid that you like to use, that you just prefer? Because I know like certain fonts are used preferred by some people. And then if you're going before the court, you have a PowerPoint, you don't want it to be distracting, but you also want it to be something that can be conveyed pretty easily. So
Yeah. So the font wars are a topic you can go into forever. I'll just say not all fonts are created equal, And when you select a font, you should pick one for user friendliness. Generally speaking, email works best with a sans serif font. The font that is the default for Microsoft Outlook right now is actually a pretty readable font, and it's a pretty good use for that. You put it in a brief and it looks silly. There are about a dozen good fonts you can use for brief writing, none of which are name Times New Roman, although they ain't going to kill you if you use that. There you want a more elegant looking serif font that's easy on the eyes. So think about screens call for certain kind of fonts, non-screens call for other kinds of fonts. There's a bunch of writing out there about that. Also, generally speaking, if it can be put in a bullet point list, that's almost certainly better than a lot of prose. But you shouldn't be using lists just to be using lists. Two other just thoughts about mechanics. Try to avoid, and this is more brief writing than it is letters to people like Dina, but try to avoid block quotes. Everybody skips over them. You may think, I've got this great quote with all this stuff. Nobody reads them. And if you look in the mirror and say to yourself, do I read block quotes? The honest answer back is no, you don't. You skip over them. The human eye instinctively skips the big wall of text. And the reason you put it in a block quote is because it was really important. You wanted to show it off. It's not going to get read. So unless there's no way around it, unless it's just what the provision is, and that's just what you have to talk about, then you just deal with it. But don't use block quotes if you can avoid that. One last thing that automatically it affects highlight all of the ways you ultimately highlight something, but try to avoid word choice. And this applies to all kinds of writing, briefs to memos to what have you. Try to avoid using words. This goes back to user friendliness that requires the user to translate them in their head. If you say the word, this is not a great example. If you say the word transaction, that's a 3-syllable word. It's big. It takes a while to read. Could you say something shorter, like deal, like contract? If you say you get the idea. But there are a lot of words we commonly use, and in conversation, it doesn't really matter because we're sort of talking and it's pretty informal. But if you use a 3-syllable word of almost any kind, there's almost certainly a 1-syllable word that it translates to. And the reader is going to stop and mentally translate it. Even if they do it in just a fraction of a second, because they're an experienced reader, it's still wasted time and it's wasted energy. So if you get rid of the block quotes and translate words down to be as short as possible while still retaining the meaning, if it's a synonym, always pick the shortest word. You got yourself a lot of progress. One final thing, I keep saying final. I started hanging around with a lot of journalists about 10 years ago when I developed my side gig as a commentator. And newspaper journalists, print journalists, now online, always write in 1 or 2 sentence paragraphs because that's how it works in a newspaper column. Longer than that's just unreadable. I've found that's extremely helpful in writing briefs for the same reason that block quotes are bad. Big paragraphs, you instinctively skip over. If you hit a paragraph that, God bless the writer, spans the entire page, people are just going to flip the page. They're not going to read it. But 1 or 2 sentence paragraphs, even if they're not literally a paragraph and your high school English teacher would get mad, are very, very easy to process. And if you take, 4 long paragraphs and turn them into 10 1 or 2 sentence paragraphs, people will actually read it and engage it instead of just flipping through it. I think you'll be surprised by the results. All right. So those are some general pointers to all kinds of writing.
I'm going to go a different direction on the visual aids and typography. I love that David Cole just gave you what fonts to use. I know there's all sorts of science on that. I'm not going to contest him at all. But what I deal with a lot is also PowerPoints. I didn't have a lot of training in PowerPoints early on in my career. And I don't know if that's the nature of the type of legal writing I was doing. But if you're in a courtroom, if you're doing a PowerPoint for your client, there are some conventions to know about PowerPoints also. They hate how many words I use. They just do constantly. That they're always saying that's just too many words. And sometimes I need those words. I need to explain what a quorum is or whatever related to an open meeting. And the specific words matter. And that is what allows me to key off it and talk about it. So the bullet points in a PowerPoint, which is another form of legal writing, is more, how do you make it as small as you can, keeping the meaning, allowing yourself to give those who are you're talking to a real understanding of what it is, but also is a talking off point. You never want people to read a PowerPoint. And the reason I was thinking PowerPoints, David, is really the visuals. You always need some type of visual to break it up. It's not easy on the legal side. But if you can find something that's thematic, that even if it's a color or a box or whatever, make it visually interesting because you're trying to keep the interest of the reader, but also have few enough words that they're not sitting there reading it as you're talking about it. And so there's kind of a balance there as well of providing enough information to allow you to talk from it, which is, the oral part of being a lawyer. I'm also going to add one more thing, footnotes. David Cole, what's your opinion about footnotes? Because I have
So
opinions about footnotes. I
it,
love
it,
footnotes.
it varies depending on the audience, right? Your user friendliness. In an email, there's no place for a footnote. My own personal opinion is that in appellate briefing, if you use what Brian Garner calls a citational footnote correctly, it can greatly enhance the clarity of your legal writing. That requires you to change the way you write. If you write just any old thing and you just move everything into all the citations into footnotes, what it's going to result is going to be hard to read and clunky. If you operate under the principle that the only thing that ever goes in a footnote is a citation, no explanation, no collateral remarks, maybe a parent on a case, that's acceptable. But no, by the way, there's this background thing that happened. If it's important, it goes in the text so you can read it. If it's a citation of any kind, case, record, whatever, it goes in the footnote. If you force yourself to do that, you will find that you end up writing in a way where you actually describe the case in the writing instead of just blurting out a bunch of citations, and that makes you a better writer. Now, some judges just don't like that. I think in large part because they have seen it done badly by people that didn't change their writing when they put a bunch of stuff into footnotes. And I think that's a valid criticism. And some people just don't like the overall look, and they're certainly entitled to that point of view. Most judges on the Fifth Circuit write the way I just described. If you look at their opinions, they use citational footnotes. The Texas Supreme Court, by and large, uses citational footnotes. So it's not just me making this up. Very sophisticated people with important messages to say are using it. So in terms of the fancy stuff, the appellate briefing, I strongly recommend that you consider using the Brian Garner citational footnote in the right way. If your forum just doesn't let it, or you just don't feel comfortable with it, don't worry about it. Life goes on. But there is substantial benefit from it if you practice it and do it right.
So I will say I probably am still resisting, David Cole. I resisted the Brian Garner way because I always felt it was important for me to know the court. And so it does matter if you're before a Dallas Court of Appeals, are you citing something from Corpus Christi or Houston or somewhere outside of the jurisdiction? I see where you're going on that. I see you want to comment.
As this court held just last year, if it matters, you put in the text. But I get it.
I hear you. I hear you. But that's the why of why I've resisted it. Why I like footnotes, interestingly enough, in-house. So there are times that I've had an opinion related to NTT, and that feels like there's snark in a footnote that could come from a court, or the other side, doesn't matter. There's snark. I don't love the snark part, but what I do enjoy is if during the research of, let's say, a jurisdictional issue, you find an interesting point about venue. And it doesn't make sense to go in the text because it's about the Texas jurisdiction, but that venue thing is I think my client is going to like to know that. If it's dropped down in the footnote, I do in fact want to know that. Because the reality of my job is I am a pure generalist. You have the ability to go deep down into the legal research of an issue in a way I just can't. My bandwidth doesn't work that way. So those kind of nuggets down in the footnotes, particularly in a legal memo, I love. I love those because that inevitably is your next memo that I'm going to ask you to write of like, hey, David Cole, thank you for the jurisdictional memo. I really needed that jurisdictional memo. But tell me more about this footnote that you talk about the venue and how does that impact this case and why and that type of thing. So in some ways, it's not, I wouldn't overuse them unless you're kind of doing the format, the kind of Brian Garner concept of citation of the case. But it is an opportunity for you to convey information in a way that you might not otherwise think fits in the text, but is helpful for me potentially.
Yeah. That makes perfect sense. User friendliness, right? Different audience, you adapt and you communicate in that appropriate way. Perfect sense.
Yeah, I think that's awesome. I think that also ties into like our next point, which is, user friendliness and talking about who you're writing to and like what you're writing for. So objective writing versus persuasive writing. I know sometimes I kind of struggled with being overly persuasive sometimes where I needed to be objective. And when I needed to be objective, I was a little bit more persuasive. And I know, David Cole, you have a good quote on this as you talk about looking before you leap. But I'll let you expand into that if you want to talk about the difference between the different
Yeah,
goals of
I guess I was thinking of mulling that distinction. So it's all who's your audience, right? And so if you're, and there obviously is substantial overlap. Just because you're writing for a court doesn't mean you lose all good judgment about how you express yourself, but you have different goals. Often when you're communicating with a client, it's your job to give them the pros and the cons. And so that's objective. You're not writing a piece of advocacy. You're saying, here's the statute that we're under, here is our argument, here's the other side's argument, here's the situation. We have this witness is going to say this, the court's going to do this, and so on. And so that's your task, is to explain what's going on and what the lay of the land is and how things are likely to come out in a relatively dispassionate way, while showing that you still root for the home team, that you're trying to do your job. There's not a client in the world that won't argue with you about that and say, well, but shouldn't we win X? Well, why don't you argue Y? And there's a place for that. But going back to audience, when you're thinking about who your audience is, when you're writing that kind of piece, where you're giving the client advice that's a little bit neutral about pros and cons, you want to be very clear and keep it in your own head. You're not really writing what you think. You're writing what you think that guy over there is going to think. The judge, the regulator, the other side, whoever it is that you're dealing with in this situation where there's pros and cons. And when the client says, well, why can't you argue X? You can say, I did. That's the second argument in the memo. And I believe you. I think that's a great argument. But what I think doesn't matter. What matters is what Judge so-and-so thinks over there. And he's got all these other things on his mind that you and I don't, that we have to be realistic about. So your audience is the same, but it's not describing your thoughts, describing somebody else's thought. And I think that's an important way to think about giving that kind of advice, where you can stand up to the inevitable. Well, what about so-and-so? Well, I agree. What about so-and-so? But we're not here to argue back and forth. We're here to deal with objective reality. So that, I think, is the main difference between the two.
And that's helpful. And I know, yeah,
Oh,
Dina, I
go
was
ahead,
going to say,
David.
I was going to say something similar for you, Dina. Like, I'm just going to ask you, because I know you mentioned the context of defining certain terms and emails and trying to communicate in terms of maybe negotiations or transactions. So I was going to ask you if there's an objective way that you like to go about that, or if there's also sometimes room to be persuasive in terms of your persuasive goals.
So on a transaction, and anyone who is on here who does transactional work knows that there's always the bigger party that has greater power for whatever reason, right? And I think everyone goes into a transaction having an idea. I think you can overcome that potentially with hard work, research, having a very good technical argument if you are the party with lesser power. But I do think there's a lot on the transactional side that is tailored to what the business objective is. And that business objective can also be a legal objective for the business. Easy example, I know I talked a little bit about jurisdiction and venue choice of law. NTTA is a political subdivision of the state of Texas. It's a governmental entity. It's very important for us to have choice of law as Texas. Why? Because outside of Texas, they NTTA may not be considered a governmental entity, and that brings all sorts of things that come along with that. Because as a governmental entity, you've got governmental immunity, you've got there are things that come with that we have to make sure. So that's an extremely important provision for me, as an example. And it's a deal breaker. If you don't agree to Texas law in a transactional document with us, we won't do work with you. It's just what it is. So there are concepts like that are absolute deal breakers, and it all depends on the party and the why. Then there are other provisions that you kind of go back and forth on, and usually at the end of the day, if you can't convince somebody that you're right for whatever the reason is, it's the party with greater power. Because I know even as a governmental entity for many, a contract that we have, it's kind of like you're going with our terms. These are governmental terms. We apply them across the board, but there are some entities that are so big. Think of like a Google or an Amazon. We can't even talk to their lawyers, much less change anything. And so we either have to figure out how to work with those entities without potentially having a contract with them, or figure out how are we okay with a contract with them. And I'm not saying it's not objective or persuasive necessarily. It's more like business goals. Like, what are the business goals and how close can you get to the business goals? I will tell you, having been on the transactional side since I've been in-house, which is now since 2012, longer than I litigated, you can totally understand why there's litigation, because transactional documents they're Franken documents, because it's the push-pull of all the sides. And if you have more than two parties, it's of the many sides. And this is exactly how you get ambiguity and litigation. So I would say the legal writing side on the transactional side is really more do your best to get to the goal with what you have, with the power that you have, and comparative to the other side.
Mm-hmm.
Yeah,
I can react to when stuff goes to litigation, Dan. Just one comment beyond what Dina said. So clients like to review, are entitled to review things. It's their piece of work, not your piece of work. You're submitting it for the client. They're one of two things that particularly corporate type clients like to add. Sometimes people like to add irrelevant detail, in part because they just are interested in it. In part, they don't really have anything to contribute and they just want to throw something in. And so getting rid of irrelevant detail and saying, thanks, I appreciate that, but we just don't need that, is a skill. There are also times when usually a larger client, but a corporate client has material they want to add or argument they want to make because they have to, because there's a business reality. The same provision is in a lot of contracts, or there's a particular jurisdiction issue that keeps coming up that you really don't have visibility into. That's just something that they have in their world. It's a risk they manage. And your piece of the brief on that is, item number 42B of a much larger issue. You need to pay a lot of attention on that. Even if it's a little bit collateral to the main goal of your brief, if there's a strategic or business reason why the client needs to argue issue A, B, or C, go there. And don't let your impulse to get unnecessary facts out of the way get in the way of that, because that's legit. If they've got a strategic goal that's a little bit different than the main goal of the brief, get them to work together. That's part of the job, because your job is to represent the client, and get them out of the case with the best result, not necessarily win the case sometimes if there's a particular issue that, recurs in a lot of places.
Let me add to that politics are real. There's a lot of politics. There are some that would have an opinion about what goes into a legal brief. Like, as an example, I've got 3 lawyers on my board of 9. And if I have a lawyer that is really interested in one particular area, I may say to my outside counsel, like, I appreciate you have that as item 5 in our brief. Can we at least move that up to item 2? Because the politics of the situation, and I have to report to the board, and they have many opinions at times, and I have to balance their opinions with what my goal is related to litigation or whatever. And so I understand that I've got internal pressures coming from every which direction, including my CEO and my peers and that type of thing, that are just straight politics. But I'll let you know. I mean, I'll be clear about it. I'm like, hey, this is what I got back from a board member. This is how I would suggest we deal with it, or we package it in this way. And so I'll be pretty upfront. But there are sometimes something as basic as politics impacts something like a brief,
No,
just
that's
what
the
it
thing.
is. Or
Clients,
transactional, to be honest.
a large client is not one person. A large client is a board, it's an in-house legal department, it's the business units, what have you. That's just the way it goes. Yep.
Yeah, it's helpful. I know we spent a little bit of time talking earlier about um, going back and forth and who you're writing to, and sometimes whenever things have been written to you from clients, and in that sense, I wanted to get to a little bit, just touch base. I know legal writing has changed throughout the time. You know, David and Dina, whenever you first started, and me, my 5 years of practice so far. But right now, we're in the advent of artificial intelligence and AI. So, you know, I know some people love it, some people hate it. Regardless of that, it is going to be something that we're going to have to deal with, and can't necessarily be a Luddite here. So, any opinions on, you know, how do you use it? How do you implement it in your day to day? And how do you deal with clients who want to submit a complete AI generated ChatGPT assignment to you and tell you
So
that
I'm
they're
gonna I'll start first because I think David has a broader usage of AI. So thus far, AI to me and what I receive might as well be your Google search does not equal my law degree. Your AI search does not equal my law degree. Like, and so I appreciate that those I'm working with, my business units, I appreciate they're educating themselves. But if someone is bound to the first draft of what AI gives them, it inevitably is not correct. And I know we've always said this, right? You got to make sure AI, what it pops out, is it right? Are the search terms correct? Whatever. And it superficially sounds good. But again, having experience in the practice of law, I know, well, that's ridiculous. And I'm able to articulate the why of why something is ridiculous. There are times that for me, the AI slop that I receive from other people just causes me to spend more time because now I have to make better something that I could have written in the first place quicker. I do recognize that AI is going to get better over time, but where we are now and where my business people are now, it seems to be I'm doing a lot of editing and correcting of things that could have been done right in the first time. As for y'all to know, that's my pain point. um, I am open to using AI. I will use AI for various different things. Interesting enough, if I'm giving a talk, I don't mind doing an outline from AI and then pull from it. It has so far not made my life easier. I know, David Cole, it has made your life easier, with the exception of a couple of things. I do think I know that Grammarly has AI incorporated because it popped up at one of our AI searches of who's using AI. I appreciate Grammarly. I think it's got some useful features. But so far for me right now, I need AI to get a little bit better because it's going to business people and then coming to me. But the thing I do like about AI, this is not legal writing, this is other things. Y'all get a million emails. I get a million emails. It's starting to summarize my emails. And I think that's been helpful for me. I need to probably leverage that a little bit more to make sure that I capture all the emails. But man, emails is, I know it's a whole nother CLE topic, David A. That's another place that AI is helping me now, not necessarily in legal writing. I'll give you an example. I had a resolution whenever someone leaves our board, we do a nice resolution for them of all the things that relate to their service on the board. If I put that into AI, asking for different ideas of the maybe 14 whereas clauses, maybe two of the whereases, I go, oh, that's an interesting idea. I wouldn't have thought about that. And I incorporate it into the final document. So that for me right now, it's still idea generation and gap filling is what I would
Mhm.
say is how I find AI to be helpful.
Yeah,
Well,
so
that's
I'll
helpful.
throw I'm in a different place in the world, right? Dina is the general counsel of a big government entity, and I'm a practicing lawyer out here. And it has been transformative in my life. It's probably made me 2 to 3 times more effective than I was over a year ago. I have generally 3 AI programs up on the screen all the time. I have Westlaw's new research thing that they launched 6 to 9 months ago that uses it's not the same old search. It's a new search where you put in an AI query and it writes you a little memo back. It's not perfect, but it's very, very good. We subscribe to Harvey, which is a proprietary service tailored to law firms. You can upload all manner of things into a case file. They have a lot of guarantees about security and privilege and all that. So those were persuasive to us. That's why we agreed to use them. And I have ChatGPT up to just for the occasional paragraph or something, or just general curiosity about the world. Um, it where it saves time and adds value is on the front end and the back end. The curse of the blank page in my business is a terrible curse. From a blank page to something that looks like a draft takes a long time. Harvey can generate a first draft in seconds if you give it the right material and set it up with the right directory. It's not going to be great. And the actual prose that Harvey generates, maybe 20% of it actually gets into the final draft, but it got me going, got me moving. And so now instead of spending that 3 or 4 days or whatever on the front end, kind of laboriously putting things in from other drafting cases, I got a draft, I got stuff, I got cases, I got record sites because it knows how to review the record. I'm good. And now I can spend that time actually doing the lawyer part, which is figuring out what to emphasize, what facts to talk up, what facts to get rid of, that kind of thing. And then on the closing end, if there's a section that's just been intractable to draft, it can help me revise it. If I've got a paragraph that just is clunky, it can fix it. And I don't give it the whole brief. I'll give it chunks and say, make this better, make this tie in with this, make this. And it helps you kind of polish out the final product. And that saves a lot of time, or frankly, adds a function you just couldn't do before. There just wasn't a way to do that. Now, some cautions. It is very good at helping you come up with ideas. It does not know any law. The technology in general, it tends to respond with the law of nowhere, which is what you learned in the first year of law school, sort of general principles. That can be helpful. It can also be wrong. That technology is evolving rapidly to go actually look at things and source things. You can tell it, I only want a response that has a footnote. And the Westlaw product is tailored to its database, so it doesn't hallucinate. It always looks at those cases. So it can be helpful with some caveats, and it's something to worry about, to know about. It, of course, hallucinates. That's the nature of AI. It is backwards looking. It never has a creative thought. All it does is go through what's been written before and tell you what's next. That can be very valuable, saving time on first draft. It cannot be creative. It's not its nature to be creative. So you have to watch out for when it just makes stuff up, and you have to watch out for it just retreading common old ground. But that's relatively minor. I mean, if it creates a first draft for you in seconds, you have 3 or 4 days to review it, here and there and everywhere, and you just have that in mind. That's no different than a human work. I know that so and so I work with has these tendencies. I know that so and so tends to do this. I know that Harvey tends to do this and this. That's not any big deal to compensate for that. So my practice, I think, is uniquely well suited to the use of generative AI because it is sort of born to write. And with careful supervision and with the technology having really developed a lot, it's been a huge time saver. The technology is changing daily. I actually subscribe to a couple of engineering newsletters. I don't understand most of what they're talking about, but it's very clear to me that on a daily basis, significant changes are being made in this industry. And over 6 months to a year, it's gaining astonishing amounts of ability. And so I don't know what it'll be doing in a year. I'm confident there'll be 3 different programs up probably. But if you're not using it, you may have a practice that doesn't lend itself to that. I've described what I do in my appellate practice. Other people do different things. Obviously, some things it can't do. It can't argue. It can't, it can't advise clients realistically, that sort of thing. But it can do a lot of things very well and save you an awful lot of time if you use it right. And if you're not seriously testing it, I strongly encourage that you do so. It can double your life, and your competition's out there doing it too. And so, if you want to keep up with Joe down the street, you got to be thinking about how to use it.
So I think I read something recently that was saying that the young people that are graduating from college, they lived in an AI world. I think
Mhm.
it's probably natural for them to use AI and leverage AI. I know my daughter does more than I do as a freshman in college.
Mhm.
So I do think for me, the caution would be David has practiced law enough to have that gut that tells you when something it looks funny, seems funny, smells funny, like, oh, let me go look more into that. He's probably going just from gut feel will know if
Mhm.
he's got some hallucinations. For those younger lawyers who are on the call who've lived with AI, just realize those hallucinations are real. You've got certifications that have to go to courts based on the legal writing that if you've used AI, you've confirmed that the cases exist, that type of thing. Just know that over time in the practice of law, you do have that gut that comes along with, that doesn't seem quite right. Let me go look into that more.
A critical thing to do, this is important anyway, any kind of legal writing, and I'm talking about brief writing here really, but you got to check stuff while you go along. You can't just put it all in there and just keep writing and writing and writing. And at the end, envision that you're going to have this massive site checking thing where you check all the sites. That won't work. You're not going to have that time. You're not going to be able to do all that. You've got to keep up with it and realistically finish the site checking when you write something to use as a case, which means you're checking for hallucinations. Right? If I've got a case and I check the quote and I check the site and everything's good, I'm good to go. And I can feel confident building on that. But if I've got a bunch of stuff that different people and AI worked on and I don't bother checking it for a while, well, that's when hallucinations can start to gather a little momentum. So don't blow off the site and record checking to the end. You got to keep up with it while you're working, or things can get in there that you don't want in there.
Yeah, that's super helpful for young attorneys, young lawyers who are going through that. I know whenever I first started, I was always looking at different templates and different forms from partners who've used it in the past, and I had to ask, where can I find this? Where can I find that? And they'd give me an example, and I'd be able to kind of work off their template. And now that people are implementing AI, a little bit more, they're trying to conflate the two. But I think working off of what a partner writes and how they write is different than working off of what ChatGPT spits out.
One other thing, by the way, that I do all the time is I put drafts in and put the other side's brief in and say, what points does this draft address well? What points need further addressing? What points, and just ask it to give me some feedback while we're going.
Mhm.
It's interesting what it does. It sometimes has very useful insight. It sometimes just blathers, but it's insight, and it didn't cost me anything other than the cost of the service, and it got it in 10 seconds. And on the other end, I don't know what judges say about generative AI, and some may not use it, but I'm confident your stuff's going to go into some kind of generative AI thing at some point with a survey the issues and tell me what the strongest ones are. It ain't going to hurt you any to put your brief in and ask that kind of question, because it's very likely that a law clerk is going to run a similar sort of inquiry about your brief compared to the opponent's brief. That's just a fact.
Yeah.
I
Well,
read something also recently that said that that's going to be a game changer for those who have a volume practice. So if you have a volume plaintiff's personal injury practice, that AI can, I mean, it's going to be amazing that it
Mhm.
can come up with questions for you, the next deposition question, things like that, things that are leveraged that kind of equalize the fact that other firms have fewer cases so they can focus more on cases. But it's that piece is definitely going to be interesting.
yeah.
Yeah.
Well, I think writing is definitely something that's near and dear to all of us. So I just wanted to, you know, get a little bit more into that in terms of what we think are some of our absolute pet peeves in writing, and then some of our war stories, if you don't mind sharing. I know you've been practicing it for some years now, so your stories are probably a little bit more interesting than mine.
Yeah, I have a lot of. You had some list of some ideas on there. Uh, I'm not quite sure what the best. I don't have any good war stories. I'll just mention one little style thing because I mentioned the
Mhm.
font wars. There's no real style thing. The one space, two space dispute. It's a little thing. People have surprisingly strong feelings about it. There is an answer to that question. Should you use one space after the period at the end of a sentence, or should you use two? And the answer is one space. That's the answer. Period. Done. There's no case for two spaces. Here's the reason: the two space protocol after a period arose from the era of typewriters, when you had a certain kind of font that a typewriter could make with a little ball that went around, and having two spaces was important to separate the end of the sentence. That mattered in that setting. When you're using modern word processing, you are not typewriting, you are typesetting. You're using proportional fonts, and you're doing what people used to do with those big metal things where they put the little metal dies in there and ran them back and forth. That's what Word is doing in its electronic fashion. And when you're typesetting with proportional fonts that you can't use in a typewriter, you only need one space. If you use two spaces, it looks weird. If you look at the whole page, these weird little rivers start to form and become distracting to the eye. I'm just telling you, that's a fact. You may have learned two spaces once. You may have always done it that way. Your partner you work for may say it. It's wrong. One space is correct when you're typesetting, and that's what you're doing unless you're using an IBM Selectric, or God forbid, you're using the Courier font, which is the only font that isn't proportionate in the modern fonts. So use one space. Little thing, but it means so much.
Very
So
passionate.
I will say on that debate, I was watching and how lawyers were going to land on the one space versus two space. And I was convinced, frankly, by appellate lawyers. The moment that appellate lawyers said one space, I'm like, good enough for me. Now let's talk about the Oxford comma. So similar to David on his research and knowing where the two space comes from, I know where the Oxford comma or the removal of the Oxford comma comes from. Also AP style, the journalists. So when they had newspaper, it was an extra thing that they had to put in the typesetting. And so that's why they don't believe in the Oxford comma. Well, guess what? We have word processing now. You don't need to have a lack of an Oxford comma, which does bring clarity to your writing. You can, in fact, just add the Oxford comma. And look, you've saved spaces. We no longer have two spaces. You now have one space. So it doesn't matter. The Oxford comma brings clarity to your writing. I've got a handful of cases that show that, where the cases have been lost due to the lack of an Oxford comma. So please use the Oxford comma. And hold on, this is this is on my pen board. Yeah, Oxford comma. When you pry it from my cold, dead, and lifeless hands. This is Texas Bar College. Seriously, y'all, please use the Oxford comma. It really does bring clarity because you know when the stop of something is. I think everyone's probably seen that book, Eats, Shoots, and Leaves. Or that you see, I don't know why they use a Hitler or whatever. You've seen the little meme on that. It really brings clarity to the writing. That's important as lawyers. We bring clarity and understanding to the reader. Please use the Oxford comma.
Go ahead, Dan. I'm sorry. I was going to add.
No, go ahead.
So the common theme here, you may know it, is modern word processing technology. Not that modern. It's been around for 30 odd years now. But here's another thing that this is a pet peeve. We have. I will freely admit, WordPerfect 5.1 was the perfect word processor. It had just enough stuff. It was easy to use. It was intuitive. It made very easy, very nice looking product, and it's obsolete. It's gone. Forget it. No one's using it anymore. Word took over. Word won. It's done. Deal with it. Word is harder to use than Microsoft Word because it uses this goofy thing called styles to organize the document. This is not the time for a lecture on styles, but it's goofy. It's not intuitive, but it exists. It's a reality. And it'll take you about an hour to learn how to use it if you just go watch a video about it and play with the document. And the immediate return on investment is if you learn how to use styles in Word. Not only does everything start looking better, but you can generate a table of contents, which means an outline, just by hitting a button automatically. You don't have to do anything fancy. You don't have to keep another outline on a piece of paper. The computer, the Word will do it for you if you're properly using styles. And I see, you talk about people that grew up in the AI generation. I guess they just missed the word generation part. You have all this stuff, and the formatting is just terrible. And it could easily be fixed if people would just take a little time to learn how to use the tools of their trade. You know how to turn on your computer. You know how to take pictures with your phone. Learn how styles work in Word, and you will be amazed by how much more effective you are with it and how easily you can generate those tables of contents and and work with them. If you're already doing that, great, I commend you. But I encounter a surprising number of people that look at Microsoft Word all day long and just have no clue how it works. And there's no good reason for that. If you're going to use the tool every day, learn the basics of styles, and you will be amazed by how much more effective you are.
It also will prevent gremlins. You know, those weird things where you add a tab and then a weird tab happens or all shifts over. Using those styles will help on that. I do want to, because I know we're running out of time, David A. I want to mention substance versus perfection. I remember, and then I'll get into a little bit war story. I remember back when the last law firm I was at, I remember talking to the younger lawyers about that, younger lawyers trying to get to perfection in a document, and it was going to a court that did not have Barbara Lynn as the judge. And I was like, sometimes the B+ effort is perfectly fine. like you can, every time I look at a document, I can always find something to change. It is true. It's just how it is. I'm sure everyone on this call does the same thing, but there's a point at which just get it filed. Sometimes just getting it filed is more important than perfection. Now, I'm going to tell you a little bit of a war story. This happened probably a couple of years ago when I was in this role. We had a litigation basically related to when people owe us a lot of tolls, usually fleets. And there was some brief I was reading. Call it a 15-page brief. By page 3, I was like, oh my God, there's so many mistakes in this. I'm having a hard time reading it. And I was like, okay, I'm going to tell the senior associate. A couple pages later, I'm now going to tell the junior partner. Like by page 10, I called the senior partner on the case, was like, I can't read this. I can't read it for substance because there's so many errors. Looping AI back into that, I think AI could have helped if you've run it through AI on something like that. But if it has too many errors, I literally can no longer read for substance. I'm not saying you necessarily have to have perfection. I would, depending on who it is that you're writing for, try to never give someone your first draft. Make sure you edit, re-edit, edit again before you give it to a partner, to a client, to a court, and that type of thing. But this was so bad. You never want your client to call and say, I cannot read this document because it had so many errors in it. Now overlay that with what I just said leading into that story of sometimes a B+ is just fine. Make sure it's not enough. Like, just whether it's you, AI, someone else, doesn't matter. Make sure it's good enough to leave your hands and go to another human who will have an impression of you and your legal writing based on what you just handed to them.
No, it's just got to get done. And there's sometimes in my practice, you find people that they'd like to make revisions, they like to make helpful suggestions, or you hand off the brief to an administrative person to help wrap it up, and they're not that used to all this stuff, and they have all these ideas, and it's just got to get done. Charles Allen Wright, the great federal courts professor at Texas, was once asked by someone, what makes a great law review? Because he taught at many universities and had a lot of experience. He said in his booming manner, there's one thing that makes a great law review. It is on time. And that's, it's got to pass the smell test. It's got to have all the right stuff in there. But if there's a typo on page 5, or you forgot to fill in the blank on page, nobody cares. The message has been conveyed, and what the court needs or what the client needs is useful, helpful information, and that footnote or whatever will just get lost in the shuffle. Don't be careless, don't be sloppy, but don't be the perfect is the enemy of getting it done. If you decide you're going to do a whole big revision with 2 hours to go, you're being an idiot. There's no point. If it hasn't been fixed by that, it's just not going to get fixed, and you just need to deal with that and move on, get it done, go on to the next case.
Yeah, I think that's a really good balance. I remember, David, when you always walk around editing your papers and you're going back and forth, pacing beside me, and editing is important, but also, as Dina mentioned, you have to get it done. And perfection is hopeful, but that B+ will get it done and be able to win the case if you're not in front of Judge Lynn. So,
who's no longer on the bench, so you probably won't be in front of her.
Well, we have just a few more minutes on. I just had a few more questions in terms of any recommended reading or suggestions that you want to leave our audience with, just so they know. I know you mentioned Charles Allen Wright and Brian Garner earlier, but is there anyone else that y'all like or y'all followed or listened to in terms of your writing that's developed your skills?
Here's one thought I'll have. There is a great deal of talking about legal writing, particularly on LinkedIn, if you just follow people that are into it, about what kind of font you use and that kind of thing. And that's interesting. I enjoy looking at it, but the trap you can fall in there is thinking that legal writing is a bunch of little gimmicks and a bunch of little tricks. And the same is true of courtroom advocacy. You can fall into that and think, well, if I know how to offer an exhibit in a certain way, then I'm going to be awesome. But that is not the goal. The goal is effective advocacy. And they're the overwhelmingly best book on that subject, generally, how to do good advocacy work, is by a guy named Herbert Stern, Stern. He was a district judge, federal district judge in New Jersey some years ago. His book series is called Trying Cases to Win, kind of a hokey title, but he is very, very insightful about how you want to balance various factors together to do good work, to be credible. And he's writing to people that are learning how to be courtroom lawyers, give opening statements, do crosses, and so on. It carries over 100% to legal writing. And I think studying his work about what to do and why will then lead you to the right style of decisions. It's good to know all that trivia about fonts and whatnot, but why you're doing it is the important thing. And Stern's book is by far the best on that.
So we use a bunch of different things. We edit the board documents before they're posted to the board and board packet and all that type of stuff. And so we do rely on like the Chicago Manual style, Grammarly, that type of thing to make sure. And we do, in fact, have debates over whether to use which type of hyphen, the small one, the larger one, the M dash, N. Anyway, we have these debates. David Cole would probably appreciate them.
Oh, interesting.
No one else. So I think those things, some of the reason we do that is, number one, consistency, because legal writing, having consistency and cross is important. And I think that prevents distraction from your audience. So those technical little things, I don't disagree with David. I think that you do need the advocacy piece of legal writing, but I also don't want to distract. Similar to being in a courtroom when I was pregnant, I remember my friend said, don't forget your wedding ring, because you don't want anyone distracted by the fact you're pregnant without a wedding ring, right? I was married. It's just that my fingers got big, right? But that concept, you don't want distraction. You don't want distraction in your writing. And so if you have time, and don't rewrite a brief 2 hours before it's due, which is always midnight because electronic filing, don't be changing things then. But if you do have time, try to the edit and re-editing. It not only polishes your writing, it catches the little things that could be irritants that you don't want someone deciding or just not wanting to read your brief because the little things are split and fin or whatever it is, adverbs, too many adverbs, no Oxford comma, just to some, those things do matter. And remember like for instance, in federal court, they have law clerks that just came off of being on law review. So all of the blue book, all of the little grammar and punctuation, that type of stuff, that's your audience there. Just remember those type of things. And if my final words are that quote that David, I don't know if you actually said these words, but I'm going to say it. There is no good writing, only good rewriting. Editing is critical. I 100% agree with that quote.
I do too. That's the mantra.
Awesome. Well, I definitely appreciate you both giving here to impart your wisdom on legal writing and everything else that you mentioned. Even your opinions on writing and your passions. It's definitely inspiring and something we can aspire to be. So just wanted to say thank you again. Thank you for everyone who's joined. It really means a lot for y'all to take the time to be on the call. And thank you for being involved in DAYO.
Thanks for having us. We really appreciate it. Take care.
Thanks, everybody.